The risks of power of attorney and what families often get wrong. This is the mistake that causes most power of attorney problems, even when everyone's intentions are good. Power of attorney is a powerful tool, but it's not something you should sign without understanding the risks. Most problems I see with power of attorney don't come from bad intentions. They come from misunderstandings. So let's talk about what people often get wrong. Hi, I'm Lindsey Egan, owner and founder of Poppy Legal Group. I help individuals and families put legal plans in place that protect them, not create new problems. And today, I want to talk honestly about the risks of power of attorney and how to use it thoughtfully and safely. If this kind of honest guidance is helpful, please follow along. I share the things people usually don't find out about until it's too late. So, understanding the risk of a power of attorney is super important. The biggest risk, though, is just not having one. The second biggest risk is giving the wrong person too much authority without clear limits. A power of attorney can give someone access to bank accounts, investments, property transactions, and legal decisions. That authority can be broad-reaching. And if it's poorly defined, it can be abused or misused. Here's a real-world example of this. If you gave your much younger spouse power of attorney because it felt easier or avoided conflict, and that document allows unrestricted access to finances, then yes, you may have created serious risk. Even if that person already helps with finances, a power of attorney removes safeguards and gives them the legal cover to act independently. That doesn't mean that you automatically messed up. It does mean that the document should be reviewed to see what powers were granted, whether limits existed, and whether protections are in place. Power of attorney really is about trust, but it's also about guardrails. A power of attorney isn't a free pass. Another misunderstanding is thinking a power of attorney gives someone unlimited control. It doesn't, and it shouldn't. The authority is defined by the document itself. It can be broad, or it can be very limited, depending on how it's written and what powers the principal actually chooses to grant. Even when the authority is broad, the agent isn't free to do whatever they want. Agents have a legal duty to act in the principal's best interests and to handle financial matters responsibly. Misusing that authority can create legal consequences. Problems usually arise when the document is vague or when expectations were never clearly discussed. If the agent doesn't fully understand their responsibilities, or if family members have different assumptions about what the agent should or should not be doing, conflicts can develop. That's why clarity truly matters. A well-drafted document combined with an honest conversation about responsibilities can prevent many of the misunderstandings that lead to disputes oftentimes later. So you can't force a power of attorney over someone. This is also really important. You can't get power of attorney over a family member unless they are willing and capable of signing the document themselves. A power of attorney must be created voluntarily by the person granting the authority. If someone lacks that mental capacity to understand what they're signing, a power of attorney may no longer be an option. The law generally requires that the person creating the document understands the nature of the authority that they're actually giving to another person. That's why timing really, truly does matter. Powers of attorney are usually part of advanced planning, created while someone still has that legal ability, that capacity to make those decisions. If that capacity has already been lost, families may need to pursue a different legal process, where a court may have to come in and decide whether someone should be appointed to manage those personal or financial matters. Choosing the wrong agent. People often choose an agent based on closeness or convenience, not on capability. Not such a great move. The best agent is someone who is organized, responsible, calm under pressure, and willing to follow instructions even when it's uncomfortable. Money matters less than people think. Having personal wealth doesn't make someone a better agent. What matters really is judgment and discipline. In fact, people sometimes choose the wrong agent because that person has more resources, when a less wealthy sibling or relative would actually be more careful and responsible. The agent doesn't need to fund decisions personally. They need to manage, execute, and document decisions properly. Choosing someone with money but poor judgment can be far more dangerous than choosing someone with fewer resources but really strong boundaries. It's also common and important, in my opinion, to name backup agents. Many power of attorney documents include and should include a line of succession, meaning a primary agent and one or more alternates who can step in if the first person can't or is not able to serve. That kind of planning ensures there's still someone available to act if and when circumstances ever change. So, not reviewing or updating the document. We all know, guys, life changes, relationships change, finances change, trust dynamics can change. A power of attorney should be reviewed periodically to make sure it still reflects your wishes. For many people, that review happens when there is a major life event, such as a marriage or a divorce, a relocation, or a significant change in maybe your health or your finances. It can also be helpful to involve the agent themselves in at least part of that conversation. The agent doesn't necessarily need to participate in the legal review itself, but making sure that they understand the responsibilities, the expectations, and the scope of authority can prevent confusion later. You're generally not stuck with an outdated document, by the way, as long as the principal still has that capacity. A power of attorney can usually be revoked entirely, replaced, or simply updated. Creating a new document and formally revoking the old one is a common way to make sure your current wishes are still being reflected. So reviewing the document from time to time helps to ensure the right person is still in place and that the authority that you granted still matches your situation. So when is a power of attorney not the right tool? Power of attorney is not the solution for every situation. If there are serious concerns about safety, exploitation, or incapacity, other legal options may be more appropriate. Knowing when a power of attorney is not enough is just as important as knowing when it is. So powers of attorney are just meant to protect, not to complicate. When the document is done thoughtfully, with clear boundaries and the right person, it can be and should be incredibly effective. Understanding the risks, though, helps people use it the right way. If you're thinking about a power of attorney and you want to make sure it's set up safely, you can book a consult with me online. We'll talk through your situation honestly, we will answer your questions clearly, and help you decide what actually makes sense for you.